Good morning to all. Today we are going to discuss the latest development that has taken place in GST. First one is no penalty under section 129 when the goods match the description in the invoice. The case involved an intra-court appeal against the dismissal of the writ petition, which sought to cancel the show cause notice and subsequent orders related to tax and penalty under the CGST Act 2017. The appellant argued that the goods detained did not differ from those listed in the three invoice and there was no intent to evade the payment of tax. The court found that the inspecting authority made extraneous observation beyond the invoice description of the goods and could not demonstrate a clear intention from the appellant to evade the tax. As a result, the court set aside the period order, stating that the condition for invoking Section 129 were not satisfied. The court directed authorities to release the detained goods and vehicle and allowed the appellant to seek refund of pre-deposit made when filing the appeal. A very good judgment which will be helpful to all of you in if your goods are captured are. The next one is the show cause notice issued beyond the time limit stipulated under section 73 class 2 is invalid. We, we have to see whether the show cause notice is issued within the time limit or not. If the show cause notice is not issued within the time limit prescribed under the CGST Act or AP GST Act, then we can challenge, and the court have held that delay in issuing the show cause notice is invalid and hence a very good judgment. If you are facing this type of litigation, then you can take the help of this judgment and fight your case. The next one is GST appeal. Availability under Section 107 does not bar revision under Section 108. The petition filed the writ petition challenging a revisional order by the revisional authority under the Section 108 of the UP's GST Act. The petitioner contended that the revision was improperly dismissed on the grounds of maintainability and merit, arguing that the revisional authority failed to apply its mind to the fact on the case as required under the section 108. The revisional authority stated that the revision was not maintainable because the petition had an option of appeal under the section 73. However, it also provided a cryptic evaluation of the merits of the case, leading to confusion regarding the nature of its ruling. The court found the order unclear and held that regardless of whether the revision dismissal was deemed on merit or on the ground of maintainability, it was improperly justified. Considering the court caused the impugn order and directed the revisional authority to reconsider the revision in accordance with the law. A very good judgment. The next one is delay in filing the appeal beyond the period stipulated under section 107 class 4 condoned, citing SK Chakrabarti precedent. The case involves writ petition challenging the order dated September 18, 2024 by the appellant authority, which rejected the petitioner's appeal on the ground of limitation. The appeal was related to the proceedings initiated under the Section 73 of the CGST Act for the tax period from July 2017 to March 2018. An order under the Section 73 Class 9 was passed on the November 24, 2023. Due to the delay of 79 days in filing the appeal, the petitioner filed an application explaining the cause of delay. The appellant authority did not adequately consider the reason for the delay and rejected the appeal solely on the ground basis of being time barred. stating that the delay could only be condoned if the appeal was filed within 1 month beyond the prescribed period. The court reviewed the circumstances, noting that the petitioner was a small partnership firm with no lack of bona fide intention of in the appeal. The court found that the appellant authority failed to properly exercise its jurisdiction and thus condoned the delay, directing the authority to hear the appeal on its merit within 8 weeks. The writ petition was disposed of without any cost. The powers under Section 73 could be invoked only when the explanation offered under Section 61 is not satisfactory. High Court ruling upheld. The petitioner, a hotel operator registered under the GST Act, challenged a show cause notice and order related to the scrutiny of his tax returns. The notice accused the petitioner of wrongly claiming the input tax rate on the certain purchases, indicating that they are not eligible for the credit under the Section 17 Class 5 of the RGST Act. The petitioner argued that the equipment purchase was essential for his business and hence should qualify for the ITC. After responding to the initial scrutiny notice, the authorities issued the show cause notice under the Section 73 without adequately considering the explanation provided by the petitioner. Subsequently, the authorities found the petitioner's reply satisfactory but still retained the show cause notice, leading the petitioner to file the writ petition. The High Court held that the authorities acted unlawfully by not following the procedure mandated in the Section 61, emphasizing that they needed to consider the petitioner's explanation before invoking the Section 73. Consequently, the court directed the show cause notice invalid and set aside. The Supreme Court sided with the High Court's interpretation, dismissing the SLP without interference. Issues regarding the service of notice are factual and should ideally be addressed through an appeal rather than through a writ petition. The writ appeal was filed to challenge the order from January 2019, which appellant claimed was never communicated to them according to the GST procedure. The appellant contested that they were only aware of this order when they received a recovery notice in May 2024. The government argued that the period recovery notice in November 2020 had a referred the order, arbitrating awareness of the order to the appellant at that time. The legal dialogue centered upon whether there was a valid service of original order as mandated by GST Act. The court concluded that issuing regarding the service of notice are factual and should ideally be addressed through an appeal rather than through a writ proceedings. Ultimately, the writ appeal was disposed of, permitting the appellant to file an appeal within 4 weeks. The appellant authority instructed to initially examine the service of notice as a preliminary issue. Assessment carried out against an individual who was deceased cannot be maintained. Fresh notice to be issued to the legal hirer. Then the limitation period for filing the appeal under the Section 107 must be counted in the calendar months, 3 months and 1 month, rather than days, 90 days and 30 days. In this case, the private limited company registered under the CGST and BGST Act sought the judicial relief for questioning an appellant order that rejected its appeal against the demand order. The petitioner contested that the appellant authority interpretation that the time limit for filing an appeal was 120 days instead of intended 4 months, inclusive of 1 month extendable period. The dispute primarily revolved around whether the appeal was filed within the correct time frame. The appellant authority had rejected the appeal based on the grounds of delay, despite the claim that it was filed within the permissible period due to the ill health of the petitioner's director. The petitioner argued that the rejection of their appeal without hearing violated principles of the natural justice and misrepresented and misinterpreted the statutory provisions under the Section 107. The petitioner relied on the precedent from the Supreme Court asserting that the correctness of the interpretation of the time frame for filing the appeal. The court ultimately found that the appellate authority had erred in its calculation of limitation period, opting instead of to count the time in days, 90 days and 30 days, rather than by calendar months. The ruling directed the appellate authority to reconsider the appeal on its merit, taking into account the reasons for the delay presented by the company. In conclusion, the court emphasized that procedural misinterpretation should not impede the pursuit of the substantive judgment, especially in the tax dispute, thereby reinstating the right of the petitioner to have their appeal heard. The provision of Limitation Act do not apply to the appeal filed under the CGST Act once the statutory time limit has passed. In this case, the court heard the writ petition that sought an extension of limitation period for filing an appeal under the Section 107 of the CGST Act. The court ruled that this petition could not be sustained based on the following key points. Deadline for appeal. Under the Section 107 Class 1, an aggrieved person must file an appeal within 3 months from the date they were informed of the decision or order by the adjudicating authority. An additional 1 month extension may be allowed at the discretion of the appellant authority if the appellant can demonstrate the sufficient cause for the delay under the Section 107 Class 4. Exclusion of the Limitation Period Act. The court emphasizes that once the prescribed period of limitation under the CGST Act has expired, the appellant authority lacks the inherent power to condone the delay beyond the period for invoking the Limitation Act, which generally allows for such condonation under the specific circumstances. Judicial precedents, factual background, conclusion. The court dismissed the writ petition, affirming that each of the appeal was filed beyond the legally permissible limit, thus lacking the merit. The ruling reinforced the importance of adhering to the strict deadline established by the CGST Act, which aims to promote timely dispute resolution and prevent unnecessary delay in the tax related matters. Ultimately, the finding underpinned the principle that statutory provisions regarding the limitation in the tax laws must be respected and cannot be bypassed by invoking the broader legal principles from the Limitation Act. Summary of the show cause notice. DRC 01 is not valid substitute for the proper show cause notice. Willfully avoiding registration and payment of dues attracts penalty. Attracts penalty. GST registration cannot be refused merely because assessee belongs to another state. May impose 5% GST with ITC benefit on the term plans. Lease property GST, ITC, legal dispute, policy change, deepen tax uncertainty. GST cuts likely soon, rationalizing of rate possible. Government plans SLP against the Gujarat High Court GST ruling on leasehold transfers. Centre's restorative GST amendment in Budget 2025 may face legal scrutiny. India's e-way bill hits a record high in January. These are the things which we have discussed today. Please go through it and understand in detail. Thank you very much and God bless you.